Uh, Hello guys, this is Mohsin Azam interacting with you from my YouTube and Facebook channel Business Innovation. Today we are going to start our third lesson of Planning Engineer and Primavera tutorials. The topic which we will discuss today is condition of contract. In the previous lesson number 2, we discussed some definition from the condition of contract. In today's discussion, we will discuss some clauses from the condition of contract which is important for the planning engineer. So first of all, we will start with dispute in projects. As it's written here, construction industry is complicated. It involves too many stakeholders such as client, consultant, main contractor, subcontractor, and suppliers, and also have constraints like time, budget, scope, risk, resources, quality, and customer satisfaction. The stakeholders does not want to lose any additional money and time rather than the project original budget and duration. When the project start deviating from the original duration and budget during the project life cycle, one or more stakeholder of the project will raise the dispute and should have to prove when who is the actual victim, and finally he deserves the compensation in terms of time and money or both. So as it's written here that in any project, whether it is if it is from the real estate, from the construction, MEP or any project, there will be number of stakeholders involved which consist of client, consultant, main contractor, suppliers and subcontractors. And in every project there will be some specified duration and budget allocated for that, and at the same time we have to take care of the resources, the quantities and the customer satisfaction. So once the project start, all the stakeholder of the project will try to keep everything in line so that they cannot lose any additional money or additional time. But at any time, in most of the cases, project will start deviating from the original baseline, either in the case of budget or either in the case of budget or duration. So those from the stakeholder, those who are feeling that they are affected from any of the deviation, either from the budget or from the duration, they will raise their voice and they will raise their claims. So once the project start deviating from the original baseline, either in case of budget or in case of duration, what will be the role planning engineer in disputes? In case of any delay, the role of planning engineer is to defend the stakeholder right. Here it means that the planning engineer who is representing the stakeholder should have to defend the right of that stakeholder, either from the contractor side or from the client side on the behalf of their employee. So if the planning engineer is from the contractor's side, he have to protect the right of contractor or either the right of employer. For the contractor side, he should have to prepare the claims or request of entitlement as per the contract with the employer. So as we discussed before, when we start any project, we should have to first sign a contract between two parties. So when the project start deviating from the original baseline or duration, or the budget start increasing for the contractor should have to raise his claim. He should have also to analyze the delay impact from the from the P6 program on the project completion and the cost prolongation. So what will be the role of the planning engineer? If he is the representative of the contractor, he should have to prepare the time impact or the impact. He should have to analyze the impact of this delay from the program, and he should have to calculate the prolongation cost for the delay. From the engineer side, he should have to review the claim and the delay impact analysis from the contractor, give final and fair recommendation to the client for the extension of time and additional payment. So those planning engineers who are representing the engineer actually here is the representative of the client for the project. So those planning engineers who are representing the engineer, they should have to analyze the delay, the claim and the impact of this delay on the project completion date and on the budget, and he should have to give the recommendation to the client based on his determination. Okay, now we will start some important clauses from the general condition of contract, which is Fidic here. Here all the references which we will give will be based on the Fidic. So these are some clauses which we will discuss, which are severely and highly important for the planning engineer, that he should have to fully aware of that. First of all, we will start with the contract. So according to general condition of contract, which is Fidic here. All the references will be Fidic here. So as for the Fidic clause 1.6, in class 1.6 contract, the definition of contract agreement is explained here. So party shall enter into the contract agreement within 28 days after the contract receive the acceptance letter unless they agree otherwise. So once the contractor receive the letter of agreement within 28 days of letter of acceptance, both the parties should have to enter into the contract agreement. It means they have to sign one agreement between two parties after the letter of acceptance. Commencement. The next is commencement of project. Commencement of project means the start of project. So first of all, the first clause is 8.1, which is commencement of work. So what the commencement of work clause says, that after kick-up meeting, the engineer shall give notice of the commencement date not less than 7 days. So once the kick-up meeting for the project is done, the engineer should give notice to the contractor to start the work, but the notice should not be less than 7 days, or else it will be written in the particular condition of contract. As we discussed before, that there will be some particular condition of contract. So if something regarding the start or the execution of the work is written in the condition of contract, it will be followed. Commencement date should be within 42 days after letter of acceptance from the client. So the project should start within 42 days of the letter of acceptance. So the client cannot delay, give notice. The client should have to give notice within 42 days of the letter of acceptance to the contractor to execute the work. So for the commencement, the engineer should give the notice to the contractor to execute the work, to start the execution of work within but not less than 7 days. So the notice should be not less than 7 days and not exceeding 42 days after the letter of acceptance. 7 days is after a kick-up meeting and 42 days after the letter of acceptance. Or otherwise, if it is stated in the particular condition of contract, the same day the project commencement or the execution will start. Right of access to the site. This is the right which the client should have to give to the contractor to start the execution of the work on site. So employee shall give to the contractor right of access or possession to all the parties of the site within the time stated in appendix to tender. So this possession or access to the site should also be defined in the appendix to tender. And appendix to tender, we already discussed that what will be the component of appendix to tenders in the second lesson, in the previous lesson. Employee may hold such right or possession until performance security has been received. Here, as we discussed before, that the contractor should give performance security bond, which is the security of the contract, to the client. If it is delay, the employee can also hold the right of access to the site. Employee shall give the contractor right of access or possession of the site within such time as may be required to enable the contractor to proceed accordingly with the substantial program. So as it's written here, that the possession of site should be given on the appropriate time so that the contractor can follow their program of work. Means that the possession should be given at such time that it cannot impact the completion of the project. Delay or incur cost as a result of failure of access to the site, the contractor is entitled for the extension of time and payment for such delay. If there is delay from the client to give access to the site, the contractor is entitled for the extension of time. For that delay, he is entitled for the extension of time and for the delay also, for the payment of delay also. The third one is 4.2. 4.2 as per the Fidic condition of contract, performance security. The contractor shall obtain a performance security for the proper performance. The performance security shall deliver to the employee within 28 days after receiving the letter of acceptance. As we discussed, the contractor should have to submit the performance security bond for the contract. So it should be submitted within 28 days after receiving the letter of acceptance, and the copy shall be provided to the engineer. So they should have to issue a copy to the engineer also at the same time. The contractor shall ensure the performance security is valid until the contractor has executed and complete the work and remedy of the defect. This performance security bond should be valid until the completion of work, but it also includes the remedy of any defect, means the defect liability period also. Okay, so as we discussed before, in the last slide, this was only the commencement. In the commencement, the important thing is when the project will start, when actually the project will start, and when and how the access of the site should be given to the contractor, and the third one is performance security. So for to start the project, these three clauses from the condition of contract is important. Clause 8.1 is commencement, 2.1 is right of access to the site, and 4.2 is performance security. Now the next is program of work. After commencement or after kick-up meeting, when the engineer will give notice to the contractor to start the execution of work, the first thing which the contractor should have to do is to submit the program of work. So here we will discuss some important clauses regarding the program of work. So the first clause here is 8.2, time for the completion. What is written here? The contractor shall complete the whole work or section within specified time for the completion, including passing of the test, completion of all the work stated in the contract to get the taking over certificate. So it's written here that the contractor should have to complete all the scope of work within allocated time, which is written in the contract, and he should have to complete all the testing also, and he should have to get the taking over certificate. So like the completion of project means to get the taking over certificate. After this, 8.3 is actually the program. What is program? This clause is related to the program, which is actually the most important part of our job of planning engineer. After receiving notice for the commencement of work under 8.1, as we discussed, this is commencement of work. The contractor shall submit detailed program within 28 days. So within 28 days after the commencement date, the contractor should have to submit the program of works. What will be including in the program of work? Sequence of work with duration of each stage. So it should include the sequence of work and the duration for each stage or activity, i.e. contract document. So these are the activities or stages. Contract document, procurement, how much will be the sequence of these activities, and how much will be the duration required for the procurement of the material, manufacturing of plant, delivery to the site, the material delivery to the site, the construction, and the erection and testing. These are the stages actually. The project will start from the engineering part. So all this contract document is actually the engineering part, which is to submit all the shop drawings, method and material submittals. Then the contractor will proceed to the procurement of the items, and then the manufacturing. At the time of manufacture, after procurement, when they have to set up their precast yards, and when the items which we procured, for which we place the order, will be delivered to site, and when the construction will be completed, and when the testing will be done. Stages for which nominated subcontractor is associated. So all the stages in which we will have to involve the nominated subcontractor. What is nominated subcontractor? Nominated subcontractor we will discuss in the same lesson in last slides, but here nominated, in simple word, nominated subcontractor is the subcontractor which is allocated from the client side. Sequence and time of the inspection and test. So what will be the sequence and time of the inspection, and how the engineer will inspect and how the testing will be done. So the procedure should also be defined in the the schedule should be defined in the program. And report includes general description of the method which the contractor intend to adopt. What will be the method the contractor will adopt for the activities and the major stages. The contractor should have to submit the program, which include the duration of each activity, and in the larger perception for each stage, and then the sequence of each stage, the subcontractor details, the testing details, the handing over details, and the method for the each stage, and the detail showing the report estimated of the number of each class of contractor personnel and each type of contractor equipment. So at the same time we have to submit manpower and the equipment detail which we will mobilize in the project. At any time, if the engineer give notice to the contractor that a program failed to comply with the contract or consistent with actual progress, the contractor shall have to submit a revised program to the engineer. So at any stage of project, as is written here, that if the engineer feel that the program which the contractor submit is not reflecting the actual progress on the site, or it's deviating from the actual progress, they can request the contractor to submit the revised program. Okay, once we submit the program, now in the second part, here we discuss the program. In the program, two things are important. When will be the completion, overall completion of the project? It should be clear from the program, and in the program, what should be including there, and how much days is required to submit the program. So as it's written here, 28 days, within 28 days after the commencement of the project, the contractor should have to submit the program of work. The program of work should include the stages and the sequence of the stages, the contractor's detail, the sequence and time of the testing, the description and methodology which the contractor will adopt to execute the works, and what will be the major stages, and what will be the report of the manpower and the equipments. Okay, so once the contractor submit the program, the next stage will be reporting in the condition of contract. Clause 4.21 is progress report. Unless stated in the particular condition, 6 copy of monthly progress report should be submitted. So as written from the sentence, that the contractor should have to submit the monthly progress report to the engineer in 6 hard copies every month. First report shall cover the period up to the end of the first calendar month from the commencement date. So the first report should be from the commencement date to the end of first calendar month. Thereafter, report shall be submitted monthly. After this, every month the contractor should have to submit the monthly report within 7 days after the last day of the period to which it is released. So for each month, within next 7 days, the contractor should have to submit the progress report. Report shall continue until the contractor has completed all the outstanding works at the completion date stated in the taking over certificate of the work. So after getting the taking over certificate, or if the contractor get the taking over certificate but still there are some outstanding works, so some time will be given to the contractor to complete the outstanding work. So after completing all the outstanding work, holding the taking over certificate from the engineer, the contractor can stop the submission of progress report. The report should include chart and detailed description of progress. Chart means the progress curves, which is S curve, and the manpower and equipment histograms. You should have to submit status of the procurement. The contractor should have to submit the status of the procurement, construction and testing, stages of the work by nominated subcontractor. Nominated subcontractor, all the works which is allocated to the nominated subcontractor, the status of this should be submitted every month to the engineer. Photograph for the progress should be submitted, and the actual record of the personal equipment and contractor personnel or manpower should be submitted every month. Quality assurance documents, testing result and certification of material. So all the testing results and the certificate of the material should be submitted monthly. Claim register. So claim register should be submitted. Clause 2.5 is actually the employer claims. So based on subclass 2.5, the employer can claim their rights, and 20.1 is the contractor claim, which protecting the contractor rights as per the contract. So the contractor should have to submit one register consist of all the claims from the engineer side and from the contractor side. Safety statistics should be submitted. Safety reports from the safety department should be submitted every month. Comparison of actual and planned progress. There should be an S curve or the progress curve in which there should be clearly planned progress percentage, in which contractor have to show planned progress percentage, that how much progress is planned for the current month and how much actually they achieve. So this was the progress report which we have to submit, and all the requirements was written here, which the contractor should have to submit every month to the engineer. Delays. Once the project start the execution, when the contractor start the execution of the project, contractor will start facing the delays. So first of all, clause 1.9 is delay of drawing or instruction. So if the contractor face any delay of drawing or instruction, they should have to refer this clause, which is 1.9. What is written here? The contractor shall give notice to the engineer when the work are likely to be delayed or disrupted if any necessary drawing or instruction is not issued within a particular time. So they should have to notify based on this clause. The notice should include the detailed drawing and instruction when it should be issued, and impact of delay. So the notice should have to give the detail of all the instruction and drawings and the impact of this delay on the program. If the contractor suffer delay incur cost, it also affecting the contractor cost wise as a result of failure of the engineer to issue the notified drawing instruction within a responsible time specified in the notice. With supporting detail, the contractor should have to give further notice to the engineer and shall entitle as per 20 extension of time and payment. So first of all, the contractor should have to give notice that we are facing delays because of these drawings or instruction. So after a certain time specified in the notice, if still they did not receive the instruction or the drawings, the contractor will be entitled for the extension of time and for the cost for the delay as per the class 20.1, which is claims if the engineer failure was caused by an error or delay by the contractor shall not be entitled for such extension of time and cost or profit. So if the delay is somehow from the contractor side, he will not be entitled for extension of time or for the cost or profit. The second one is unforeseen physical condition. If the contractor face on site some unforeseen physical condition, like as is defined here in class 4.12, means that natural physical condition, obstruction or pollutant which the contractor encounter at the site at the time of execution of the work. It also includes subsurface and hydrological condition, excluding climate conditions. So it is written here clearly that the climate extreme or some rainfall or winds or storm will not be considered as unforeseen. But the hydrological condition, like if the dewatering was not planned but we face the higher water level and we have to do the dewatering, so it will be covered there. If the contractor encounter adverse physical condition, he shall have to give notice to engineer as soon as practicable. The notice shall describe the condition so the engineer can inspect. Meanwhile, the contractor shall continue execution of work and shall comply with the instruction by the engineer. If the instruction constitute a variation, class 13 shall be applied. So the contractor should have to give the notice to the engineer for this unforeseen physical condition, and he should have to submit all the detail so that the engineer can inspect, and meanwhile he should have to continue with the progress of work as per the instruction by the engineer. But if this unforeseen physical condition constitute of a variation, like if the contractor is deviating from the original scope of work, he will be entitled as per class 13. Class 13 we will discuss later on. This is variation actually. Variations we will discuss in the upcoming slide. If the contractor encounter physical condition which are unforeseeable and suffer delay or incur cost due to these conditions, the contractor shall be entitled as per the 20.1 for the extension of time and payment of such cost. So as it's written here, that if this if unforeseen physical condition suffer delay in the project or it increase the budget of the project, the contractor will be entitled for such cost and delay as per the class 20.1. After receiving such notice, the engineer shall proceed in accordance with the subclass 3.5. Subclass 3.5 is actually determination. This we will discuss also in the upcoming slides, but determination is that they have to inspect what the contractor is submitting, and they should have to determine the delay and the incur cost, and they should have to give suggestion to both the parties or the recommendation both the parties accordingly. Okay, the next one is 8.5, delay caused by authority. As we discussed delays in delays 1.9, this is delays of drawing or instruction, and 4.12 is unforeseen physical conditions. After this, the next one is delay caused by authorities. This is 8.5, delay caused by authorities. If the following condition applies, the contractor has followed the procedure laid down by legal constituted public authorities of the countries, and the authorities delay and disrupt the contractor work. The delay and disruption was unforeseeable. If the authorities of the countries delay or interrupt the work of the contractor and this delay was unforeseeable, then the delay and disruption will be considered as a cause of delay. Under 8.4, he will be entitled for the extension of time. After this, 19.4,
consequences of force majeure. So first of all, we will discuss here what is force majeure. So 19.1 is actually the definition of force majeure. Force majeure is war, terrorism, disorder, strike, explosive material, and earthquake. So any event from all these will be considered as force majeure. And 19.2 is the notice of force majeure. If the party is preventing for the performing any of the obligation under the contract by force majeure, then he shall have to give party to the other notice to the other party of the event or circumstances constituting the force majeure, and shall specify the obligation, the performance of which is or will be prevented. The notice should be given within 14 days after the party became aware. So the party which is affected by the force majeure should have to give notice within 14 days when he become aware of the event. So what will be the consequences of the force majeure? The consequences will be the contractor is preventing for the performing any of the obligation under the contract by force majeure of which notice has been issued. As we discussed here, within 14 days you have to give the notice. So under 19.2, and suffer delay or cost or increase in cost or budget of the project due to force majeure, the contractor shall have be entitled for the extension of time and for the cost incurred under subclass 20.1, which is contractor claims. So we discuss here actually four events. One is delay of instruction and drawing. The second one is unforeseeable physical condition. The third one was delay caused by authorities, and the fourth one was force majeure. So if the contractor face any delay, he will be entitled for the extension of time and for the additional payment under subclass 20.1, which is contractor claims. Next one is variation. What is variation? So variation is the change in any scope, the changes in the scope of work or any additional work which is instructed by the engineer. So first of all, we will discuss here 13.1, which is right to vary. So as is written here, variation may be initiated by the engineer at any time prior to the TOC of the work, either by instructing or by requesting for the contractor to submit a proposal. So at any time before taking over certificate, if the engineer instruct or request the contractor to submit any proposal for any additional work, the contractor shall execute and bound by the variation unless the contractor give notice to the engineer. The contractor cannot obtain the good within allocated time required for the variation. So he will be bound to do the variation if he received the instruction before the TUC, but if the goods are available in the specific time. Upon receiving the notice from the contractor, the engineer shall cancel, confirm or vary the instruction. So once the contractor receive the notice from the engineer for the variation, he should have to give notice to the contractor whether he is accepting or whether he can give any valid reason of the shortage of material. So upon giving notice, the engineer shall cancel the variation or he can confirm. If the contractor agree, he can confirm or he can vary the instruction. Variation may also include. So what are the variations? Actually, change to the quantity of any of the item of work including in the. So the quantity, or if the quantity of the work is increased, it means the quantity and the other characteristics are changed. If the quantities are changed and the other characteristic of the work is changed, change in level, position or dimension of any part of work, omission of any work unless it is to be carried by, if something is omitted from the project, any additional work, plant, material or services necessary for the permanent work, including any associated testing and completion. So any additional work like plant, material or services with the testing, change to the sequence and time of the execution of work. If there is any change in the time and execution of the work, contractor shall not make any alternation or modification of the permanent work unless and until the engineer instruct or approve a variation. So once the engineer give notice for the variation, the contractor should have to give the confirmation or notice regarding whether he will proceed with the work or if he have any obligation, like if there is any shortage of the material, he can give notice to the engineer regarding the situation and once they get agreed for the variation, then the contractor can change the sequence or the procedure or the methodology of the permanent work. So unless the variation is get approved by the engineer, the contractor should have to follow the same procedure as previous. And what are the variation is actually change in scope or the characteristic or the dimensions and of the work or any omission from the work or the change in the sequence of the work or the installation of any additional facility. These are all the variation. Okay, 13.3 is variation procedure. If the engineer requests proposal prior to instruct a variation, the contractor shall respond in a written as soon as practicable, either by giving reason why he cannot comply or by submitting. So, after requesting the proposal from the contractor should have to give response whether he can proceed with the work or if he have any reason that he is not in the position to proceed with the variation. If he is in the position, he should have to submit a description of the proposed work and the program for execution. So once the contractor agreed that he will proceed with the variation, he should have to submit the detailed description of the work including the program for the execution, the contractor proposal for any necessary modification to the program according to it. And as we discussed, 8.3 is the program. So if the contractor want to change the original program, he should have to submit the proposal and the time for the completion. And if he need the further time for the completion, he should have to submit the additional time required for the completion for the project, including this variation. The contractor proposal for the evaluating of the variation. The engineer, after receiving such proposal, responds with the approval, disapproval, or comment. So once the engineer requests proposal from the contractor regarding the variation, the contractor shall have to give a valid reason not proceed with the work, or he may submit the proposal consists of detailed description of the work and the program for the execution, and the proposal for the modification of the program and for the additional time requirement, and the proposal for the evaluating of the variation. After receiving the proposal from the contractor, the engineer should have to give a response with the approval, disapproval, or with any comments to the contractor. Okay, the next is extension of time. So after any delay, as we discuss here, delays, and after this we discuss the variations. So if we have any variation or delays in the project, then the contractor should have to submit claim for the extension of time. So what is actually extension of time? Extension of time, as it's written here, 8.4, extension of time for completion. So if the contractor shall be entitled for the extension of time for the completion according to subclass 20.1. 20.1, as we discussed before, is the contractor claims if the completion of the purpose of 10.1 taking over of the work or section will be delayed by any of the following reason. So if the completion of the work, either to get the taking over certificate for the project, is delayed by any of the reason given below. The first one is variation, or cause of delay given an entitlement to extension of time. Any delay from either from the engineer or from the client for which the contractor is liable for the extension of time. And exceptional adverse climate condition, this we discuss also in delays, that if there is unforeseen physical condition or climate condition, an unforeseeable shortage of availability of personnel, goods due to pandemic or government action, delay or prevention caused by employer and employer other contractors on site. So contractor will be entitled for the extension of time under subclass 20.1 if the taking over certificate as per subclass 10.1 is delayed for the complete project or for the section, if he pays variation, if there is some additional scope added in the project, or delay giving entitled to the extension of time, or adverse climate condition, or the shortage of manpower and equipment, or delay by the employee or the employer or other contractors. If the contractor consider himself to be entitled for the extension of time, the contractor shall give notice to the engineer in accordance with subclass 20.1. So the contractor should have to give notice to the engineer under the contractor claim class 20.1. When determine each extension of time, the engineer shall review previous determination and may increase but shall not decrease the total extension of time. So the contractor should have to keep on submitting the notices under subclass 20.1 for all the delays, and the engineer should have to determine each extension of time, and he shall have to also to review the previous determination, and he should have to increase the time for the completion of the project, but he cannot decrease. So once the extension of time is given to the contractor, the engineer cannot decrease the total extension of time. Okay, so next is revise program. So as per condition of contract 8.6 subclass rate of progress, at any time if the progress is slow to complete with the time for the completion, or the progress has fallen down or may fall down behind the current program according to 8.3. So if the progress is slow and the project will not be completed on time, or if it is slow and it's behind the program as per the subclass 8.3, then other than as a result of a cause listed in 8.4, if there is any delay in the project under subclass 8.4 and the contractor is entitled for the extension of time, the engineer may instruct the contractor to submit under 8.3 revised program supporting the report describing the revised method for which the contractor proposed to adopt in order to execute the progress and complete the project within the time for the completion. So if the progress is slow, or if the contractor is behind the submitted program under 8.3, he should have to submit the revised program with all the supporting documents, and he should have to describe how he will what procedure he will adopt and how he will expedite the progress so that he can complete the project within the specified time if he is not entitled for the extension of time. Unless the engineer notifies, the contractor shall adopt revised method which may be require increase in the working hours or increase in the number of contract personnel or goods, or both, at the risk and cost of contractor. If the revised method cause the employee to incur additional cost, the contractor shall subject to 2.5 employee can pay the cost to the employee in addition to delay damages under subclass 8.7. So the contractor shall adopt the revised methodology. So once the revised program is submitted, before the approval, the contractor should have to follow the revised methodology, and he should have to increase the working hours and the personnel from the contractor side on his risk to achieve the target completion date. If the revised methodology or the revised program or the method which the contractor will adopt to achieve the target incur the cost of the project for the employer can protect their right under subclass 2.5. So the contractor should have to pay the cost to the employee in addition to delay damages under 8.7. What is delay damages? If a contractor failed to comply under 8.2, 8.2 is time for the completion. The contractor shall pay the delay damages to the employee for this default subject to 2.5 employer claim. So if the contractor failed to complete the project within allocated time under subclass 8.2, he should have to pay all the delayed damages to the employee under the subclass 2.5, which is employer claim.